Good morning. Welcome to Pepperdine University School of Law. I'm Jeff Baker. I'm an associate clinical professor of law here at the law school, and I'm the director of clinical education. And for today, at the request of my dean, the organizer of this conference, and I am happy to do it and happy to welcome you all here. And today we gather for Student Life, Relationships, and the Law, Confronting Domestic Violence in Higher Education. We are joined by panelists and speakers from schools across the country. We are joined by guests from universities all around Southern California, and we welcome you all. I will have some more comments to make in just a moment, but first, to welcome you formally, I ask you to welcome our Dean, Deanelle Reese-Taha.
Thank you, Jeff, and I'm so pleased to see all of you here. Before we begin today, I'd like for you to recognize Jeff and Donna Brabick, who have done the big heavy lifting for this. So thanks to both of you. I want to give a shout out, and it's one that a dean rarely gets to do in front of an academic audience, which is to say, we had a donor who asked us to do this conference. I probably would have thought of it on my own, but I didn't, and I take no credit whatsoever. A donor who, as a result of a very, very sad and tragic domestic violence incident, said to us, yes, I'm happy for you to be one of my beneficiaries, but if you are such a beneficiary, you need to be part of the solution. And so this donor, I'm also happy to say, is a woman. Regrettably, she's in France and she can't be here today, but she sends her greetings. I believe that may be very unusual for a donor to say, you need to help chart the course for the future. So this conference really grew out of that. And I want in absentia to say thank you to Laura Sudro-Rippey, who is our benefactor and the person who got us on this track. Second, I want to thank all of you. I'd also like to take credit for my brilliant timing, but can't do that either. It got planned long before. We started the planning long before national headlines were literally daily and hourly on this topic. And at that time, Jeff came to me and said, well, first I went to Jeff, because I knew he had a heart for this work. And when he came to us, he had already run a domestic violence clinic at his prior school, one reason we wanted him here. I went to Jeff, and Jeff said, I know the best people to do the presentations around the country, and you're all here. So I'm so grateful to you. You've traveled, many of you, from very long distances. We are about very serious work today, and I'm hoping it is work that will ripple around the country, because in the shouting of the headlines and in the cacophony of who did what, when, and who said what, and videotapes and all of the sort of the public cacophony, I think there's an underlying silence. An underlying silence about the legal issues involved, the enforcement issues involved, the reporting issues, and, hate to say it, even some very personal angst about what is appropriate, where do we go, how do we respond, because we are talking about some of the most intimate relationships that human beings have. So I am so grateful to you for, I will say, leading this national conversation. It's also an international, by the way, conversation. We at Pepperdine are deeply committed to our students, our staff, and our faculty as whole people. So this topic is central to the work that we do as an institution. And it is central to who we are in relationship with this community. So it is right that Pepperdine convenes this program today. And it is right that we have called you here, and that is the right word. Called you here to try to inject into this conversation the thoughtful, reasoned, careful voices that you are. I am a recovering federal judge, and I was thinking this morning, people often ask me, you know, which were my favorite cases and opinions, and I never pick one. But for today, I started to think about one opinion that was a very long time ago. And it was an intentional tort case and involved a police department. And it was long, long before patterns and practices were sort of the tests for police department behavior. And I held a police department accountable for a pattern of practice and practice of ignoring domestic violence calls. And I got lots of letters from lots of advocates and activists around the country because it was such an unusual step to take. But it wasn't a crazy legal step because all you had to do was look at the statistics. And some very good lawyers presented those statistics in the record to show that if it was a rape, or if it was a breaking and entering, or if it was a killing or robbery of any kind, they always followed up on those. But if it was an internal domestic violence case within a home particularly, or in this case a residence hall, they didn't follow up on it. The law did a little pivot after that. Maybe not as much as we'd all hope over time in all places, but I think you will each have your own stories like mine, where each of us in our own places and in our own ways can pivot just a little bit in consciousness raising, in doing the right thing both legally and socially, and I say economically, because it has such important ramifications. So, to all of you, thank you for your work. It has never been more important. I'm always a person to see some silver linings, and I think it's fair to say we've got their attention on this subject. I was with the head of the NFL Players Association night before last, and we had a really interesting conversation on this. I actually invited him out to the conference. He was unable to attend, but he's a great guy, and they're doing some very interesting work with the players. But the point here is quite simple. It's our mutual responsibility, not just to take this seriously, but to move the conversation and pivot the people. So welcome.
Thank you, Dean. I'd like to continue making a few statements of gratitude to folks who have helped us pull this off. In addition to Laura Sudro-Rippey, I would like to also thank Dean L. Taha, because she has provided the resources and ensured that we had the opportunity to do this, and has not turned down any reasonable request, and all I made were reasonable requests. So she's been very generous to make sure that we could do it. I also want to thank our organizing committee from Pepperdine. That includes Professor Emeritus Janet Kerr, Professor Carol Chase, Maureen Weston, and Tony Miller, and other members of the organizing committee from other schools are my friends, Lee Goodmark, Margaret Drew, Tanya Cooper, and Alicia Durfee, and they have been great sources of wisdom and guidance, but also they serve, I don't know that they knew that they were going to be, but they ended up serving as conveners of panels. And it is by, I believe that relationships are the coin of the realm. And in domestic violence work, we often talk about coordinated community responses. And so I just called my community, and my community turned out and made some incredible connections. So I'm very grateful to them. And to the panelists, whom you will meet with proper introductions later. And to our keynote speaker, whom you'll hear later today, Dana Bolger. She is the founder and co-director of Know Your Nine, which is an extraordinary organization that is having a remarkably quick and fast national impact on these questions of sexual assault and domestic violence in university life around the country. Our student volunteers today, whom you will see throughout the day and tomorrow, are Ashley Crump, Mina Gayhart, Tori Slatton, Lorella Hess, April Evans, Dominique Onade, and Nicole Aronson. And our Pepperdine staff has been very helpful. Haley Grasandra is our new events manager, and I thank God that we have one. She's fantastic. And our student worker in the clinics is Madison Edwards, and she has been very helpful, especially with little touches on gift bags and email finding and lots of important work that often goes unnoticed. And then I would like to praise and laud and magnify Donna Brabeck, who has already received praise and gratitude, but I want to give her more. She's our program manager in the clinics and does so much more that is not included in her job description, including running a conference, and so that is phenomenal. One bit of housekeeping before I sort of launch the conference with some substance, as we say in law school. We have a late addition to our lineup tomorrow in what is called our closing session. This doesn't appear in your materials because she confirmed we were having negotiations, and she came in a little bit late to get onto our formal program. But I'm proud to say that we will be joined tomorrow by Anu Mira Bargova. She is the chief of the Educational Opportunities section of the Civil Rights Division of the Department of Justice, and she is also part of the White House Task Force to prevent sexual assault on college campuses. But what that should mean to all the people who represent universities here, and especially perhaps the lawyers who represent universities here, is that she is the Title IX enforcer. That may not be how she says it, but she's running a few investigations right now and doing some other things. So it'd be interesting to hear her point of view. And in her absence, I will say, please don't be fearful of the man. I think she's going to be fine, and we don't need to worry about too much liability because this is being live streamed anyway. So just enjoy your academic freedom and enjoy what the Department of Justice has to say to us. She'll be our closing speaker tomorrow. Now let's get underway. The contemporary movement to confront domestic violence began in the late 1960s, early 1970s, and it has evolved in waves of activism and reform since then, from the early shelter movement to dominance feminism and law enforcement responses to coordinated community responses and to family justice centers, and to even, I would suggest, our conference today is part of that movement. Every state in the country now has statutes for civil protection orders and specific statutes to address domestic violence. The Federal Violence Against Women Act has created structures and funding for initiatives nationwide. Title IX provides civil rights protection to civil rights gender protection on campuses, all campuses who receive federal funding around the country, and that is going to be the crux of our first panel today. This fall, here in California, many of us were very happy to welcome the addition of the new Yes Means Yes law, which requires affirmative consent on college campuses. It requires universities in California to adopt policies that require affirmative consent. No does not merely mean no. We now have to have affirmative consent that yes means yes. And as a lawyer, and as a law professor, I question perhaps some of the enforceability of that law. I do not question the cultural effect of that law and the activist effect of that law, that it can change our conversation in profound ways. We're in an increased season of awareness about domestic violence that we in this movement, even those who are relatively late to this movement like me, who have been involved probably only for 8 or 9 years, know is a long time coming. But nonetheless, we see in the news stories about Ray Rice in the NFL, U.S. District Judge Mark Fuller from Alabama. We see some very high-profile cases. And I'm wearing a purple ribbon because somewhere several decades ago, somebody said that this is Domestic Violence Awareness Month. So we are timely, and we are part of a moment where the conversation is changing. So after a generation of study, reform, and learning, we think we know a few things about domestic violence. But first, I want to try to offer some definitions. We'll likely use several terms almost interchangeably this weekend. As you in this field know, we will talk about domestic violence, We will talk about domestic abuse. We will talk about dating violence. We will talk about intimate partner violence. The language is malleable and changes to adapt to different contexts and different relationships, but generally what we are talking about is this. We're talking about abuse within an intimate partnership, an intimate romantic relationship perhaps, and that abuse can be physically violent. It can also be, and actually more often probably is, emotionally, psychologically, financially, sexually, and socially violent, not merely physical violence. We're not talking about temper issues. We're not talking about anger management. We're not talking about substance abuse, although some of those things will intersect with our conversations and what we're talking about. What we are talking about is systemic, varied, and intentional strategies and tactics to coerce one partner to the other's will, to subjugate one partner to another's power and control, to diminish one partner's dignity, to serve the other's objectives and gratifications. This is coercive control expressed in many forms, including physical and sexual violence, and countless customized emotional and psychological plays to control and to possess the other in an intimate relationship. So what do we know, or what do we think we know about domestic violence? We know that intimate partner violence is overwhelmingly perpetuated by men against women. Although we will discuss intersectional dynamics and we will discuss exceptions to that, and we will discuss problems with gender essentialism, we are certainly talking about gendered issues, and we are certainly talking about gender-based abuse. These abusive relationships find their sources in generations of sexism and misogyny and corrupted concepts of manhood and womanhood. We also know, or think we know, that the single greatest indicator of who will become an abuser and who will become a victim is the same thing, that they witnessed abuse in their own homes growing up. If this is so, if private relationships reflect the values of home and culture, and if this movement is only a generation old, we know that we remain, even now, in the dawning age of awareness and justice for victims and abusers. We know that we are in a generation that is standing against literally hundreds of generations of silence and suffering and cultures that subjugate women to the uses and enjoyment of men. We're in a transitional age where we are advancing the dignity of human rights of all people. The call for justice for women and girls in the world is the human rights cause of our age. Today, the Nobel Peace Prize went to two recipients, two girls, one from India and one from Pakistan. Pakistan, Malala Yousafzai. Oh, I'm sorry, I botched it. Malala. We all know Malala. Malala received the Nobel Peace Prize today. She's an advocate for girls' education and empowerment. And from India, Kailash Satyarthi share it today. That is an indicator that we have a moment on our hands, a moment of movement that requires our utmost attention. About domestic violence, we also know that the most effective responses are coordinated responses across local and national communities to address the immediate needs of victims in trauma. But we also know that we have to intervene and prevent abusers from their coercion, but also to address the culture of a society in advance of abusive relationships and to react positively to restore justice, to make right what has gone wrong. We need responses across disciplines and professions that engage policy, mental health, physical health, law enforcement, and education. We need to engage people in these relationships to empower those who would be oppressed and to raise the costs on abusers. We must make abuse and violence rare and intolerable. But presently, even in spite of a generation of movement and activism, we know that abuse and violence is common and tolerable. We are not surprised. We expect it. Just as in all of society as well, to bring it home to what we're talking about today, domestic abuse, intimate partner violence is epidemic among college students just as much as it is in every aspect of our communities, and we have miles to go before we achieve justice and peace and restoration. In higher education, we claim the sacred space of educating young adults, of preparing them for professions and civic engagement. We believe that we prepare our students to excel in the marketplace and society to make great contributions. And at our best, we are in the work of identity formation, to empower students to understand their world, to build their own lives, and to make that world better. And if we are true to our calling, we should consider more than just transferring information from our brains to our student brains, but we should build communities of dignity for all people with the highest expectations for peace, love, and justice, where students can learn fruitfully in their disciplines and where they can learn how to live and love well and abundantly without fear and with dignity and with confidence. We must build communities of learning where students know and honor their own worth and the dignity of their peers and their partners. This is our hope for our days together, to seek justice and to build communities here and in our own schools, communities of dignity and peace and flourishing. And today, we begin that discussion with a panel that has been convened by Professor Lee Goodmark. Our own Professor Carol Chase will introduce the panel and moderate our first discussion. And so I invite them to come down to the well and take their places, and we'll get underway.
Good morning. My name is Carol Chase, and I'm pleased to introduce the first panel of the conference. The convener, as Professor Baker mentioned, is Professor Lee Goodmark. Professor Goodmark is a professor of law at the University of Maryland Francis King Carey School of Law, where she also directs the Gender Violence Clinic. Her scholarship focuses on domestic violence, and her works include a book, A Troubled Marriage, Domestic Violence in the Legal System, as well as numerous articles on the subject. Professor Goodmark served on the faculty of the University of Baltimore School of Law from 2003 to 2014. She is a graduate of Yale University and Stanford Law School. The panelists include Professor Nancy Chi Cantalupo. Professor Cantalupo is a researcher at Georgetown Law and is the Associate Vice President of Equity, Inclusion, and Violence Prevention at NASPA, Student Affairs Administrators in Higher Education. She has nearly 20 years of experience combating sexual harassment and sexual violence in higher education and has taught courses at Georgetown, George Washington, and Temple Universities. Her research has appeared in numerous journals, and she has contributed to 2 books. Professor Cantalupo received her JD from Georgetown Law School. Professor Jill Engel directs Penn State Law School's Family Violence Clinic. Her scholarship examines the rights of domestic violence victims, economic rights of divorced women, international domestic violence issues, and best practices in legal education. She also has a lengthy history of engaging in public interest work and was the recipient of the Pennsylvania Bar Association's 2010 Pro Bono Advocate Award. Professor Engel earned her law degree cum laude from American University. Finally, one of our own, Nadam Moini. Ms. Moini has served as the Assistant General Counsel at Pepperdine University's General Counsel's Office since August 2011, and she is responsible for Title IX and Clery Act compliance and training. She's a graduate of the University of California at Berkeley and has received her JD degree from the University of Colorado School of Law. So with that, I'm going to turn the panel over to Professor Goodmark.
I always love how the beginning of conferences are all about thank you. So thank you, Professor Chase. Thank you, Dean. Thank you, Jeff. Thank you to our amazing panelists. One of the great things about being a convener is I don't have to do anything else after this. So I just wanted to give you a sense of kind of why this panel is. When we started talking about the idea for this conference, it was right at the beginning of the kind of huge wave of Title IX action that was taking place all across the country. And it seemed to us that it would be disastrously remiss not to think about the ways in which Title IX could be used not only to address sexual assault, but also to address intimate partner abuse. Now, to say it that way makes it sound like there is a division that actually doesn't exist in a great many cases. Many of these cases of sexual assault involve domestic violence, and many of our cases of domestic violence involve sexual assault. They're enmeshed in lots of ways. But what we hoped to do is to carve out a bit of space in the discussion to think about ways that Title IX could be used not only in the context of sexual assault, but also in the context of intimate partner violence that doesn't necessarily involve sexual assault or doesn't look like the other kinds of cases that we're seeing. That's a conversation that I think is not happening as much as it should be, and we're hoping that we've given you an opportunity to start that conversation today. So that being said, each of our panelists is going to take about 18 or so minutes. I have been compared to Mussolini in my ability to make trains run on time, and I will be the timekeeper to ensure that we leave you a great deal of time at the end for conversation amongst our panelists and with all of you. So with that, I'm going to turn it over to Nida Moaini.
Thank you. Again, my name is Nida Moaini, and I am the Assistant General Counsel here at Pepperdine. I like to say, for the people in this room who do not know me, my first name is pronounced like ta-da, Nida, not nada, which is nothing in Spanish, so a whole different thing. So anyway, my job here today is to provide a quick overview on the laws that govern intimate partner violence on campus. Also, I'm going to briefly talk about some of the incidents of that type of violence on Pepperdine's campus, and also Pepperdine's approach to handling those incidents when they're reported to us. And then I'm going to quickly go over our training efforts in this area. So first, there are two federal laws that govern this area. The first one is Title IX. This is the federal law that governs sex discrimination on college and university campuses. This sex discrimination includes sexual harassment and sexual violence. There is some debate right now on whether or not Title IX would cover domestic violence, dating violence, and stalking, but Nancy's going to get into that topic during her presentation. Title IX covers the entire campus community, including staff, faculty, students, guests, and vendors. For the purposes of this conference, we're mostly focusing on students. And then also, this law applies not only to your main campus, but any other domestic or international campuses you have. And then throughout the presentation, you'll hear us talk about the Department of Education's Office of Civil Rights. That is the government entity that enforces Title IX, and we'll refer to them or others on the panels probably as the OCR, so you'll hear that term. In April 2011, the OCR issued the Dear Colleague letter, and what that letter is basically their view on what Title IX requires us to do on college campuses on enforcement. It's not the law, but it's the way they interpret the law. It was almost about a 20-page letter with very detailed directives on what universities and colleges have to do to be in compliance. And I believe it probably was likely in response to several high-profile matters in the 2000s, including the Duke lacrosse and the University of Colorado football recruiting sexual assault scandals, and also increasing focus on such statistics by the National Institute of Justice on the prevalence of sexual assault on college campuses. A lot of you in this room have read those statistics. 1 in 5 women during their college years have been victims of either attempted or completed sexual assault, and about 6.1% of men report the same thing. More recently, we've received guidance on Title IX from the White House. In January 2014, a task force was convened by the White House called the White House Task Force to Protect Students from Sexual Assaults. That task force in April 2014 issued some guidance. I believe it was about a 23-page report, and then there was also a 53-page question and answer document that was published around the same time. This guidance is very, very detailed. We've spent a lot of time going through it, but it's so detailed that it even really tells us how we're going to refer to the victim is going to be considered the complainant and the perpetrator is the alleged perpetrator. So it really tells us even how we have to refer to individuals on our campus that are involved in these types of claims. Additional guidance has been coming out. There's been some model policies that have been released in the last month. And also, we expect additional guidance to come out from the White House Task Force. If anybody's interested in seeing this guidance, all of it is on notalone.gov. The other federal law that governs this area is the Campus Save Act. This is really a law that increased, thank you. I think I have my other slide up here. This is the law that basically mandates increased transparency on campuses regarding the scope of sexual violence, and also broadens the definition of sexual violence. So sexual violence does not just mean sexual assault. It also encompasses domestic violence, dating violence, and stalking. So essentially what the Campus Save Act has done is apply most of the Dear Colleague letter requirements to these additional categories of sexual violence. And also, as was discussed in the introduction to this panel, there's also the Yes Means Yes law that was recently passed in California. Not only are we talking about consent in that law, but that law also says that public and private schools in California must also provide training and victim-centered protocols on the subjects, or actually in the areas of domestic violence, dating violence, and stalking. So there is some discussion in that law that goes beyond just sexual assault. So together, Title IX and the Campus Save Act, what they do together is, once again, they increase the transparency of sexual violence on campus, which means that in our Clery Act reports now, we have to actually report out on domestic violence, dating violence, and stalking. And then we've also been told that we obviously have to update policies and procedures and adopt certain hearing procedures in these types of cases. And also we've had to designate Title IX coordinators on our campus, which at Pepperdine we have 3. We have our lead Title IX coordinator who has general oversight on Title IX claims, but that individual also handles employment, guest, and vendor claims. And then we also have a deputy Title IX coordinator who handles all student claims, graduate and undergraduate. And then we also have another deputy Title IX coordinator in athletics who gets a smaller subset of the cases that involve athletes and coaching staff. And finally, both of the laws require that we provide training to both our students, employees, and the entire campus community on these issues, as well as train our investigators and train those who adjudicate these types of cases. So just very quickly, at Pepperdine, what we've seen with intimate partner violence incidents on campus, we took a look at the statistics, and unfortunately, it's really kind of hard for us to assess at this point, because up till very, very recently, we haven't had to track these cases or really categorize them in a way that's going to show, yes, this is a domestic violence case, this is a dating violence case, this is a stalking case. So the accuracy of these numbers is really questionable, but in a 5-year period, what we're finding in the student realm of student claims that are domestic violence, dating violence, and stalking is we have between 1 and 4 of these claims on campus a year. But also keep in mind that this also does not match up necessarily with what we would have to report with the Clery statistics, because Clery focuses solely on the Clery geography, which is pretty much what happens on campus or our other campuses. A lot of these cases, and from what I've read in the reports, they occur off campus in somebody's apartment or home. So, so those 1 to 4 cases would probably not have necessarily showed up in our Clery statistics. The only year we have Clery statistics on those 3 new categories is for 2013, and they've just got published on October 1st. And what we had in our statistics were 0 domestic violence, 2 dating violence cases, and 0 stalking cases. And both the dating violence cases were student cases. So I suspect that we're going to see more of these types of cases get reported in our Clery statistics. I think now with the changes in the law and more media attention on these issues, that this is going to, we'll definitely see an increase in these numbers. So what is Pepperdine's approach when we do get a report of intimate partner violence on campus? What we do is we consider this to be a violation of our discrimination, harassment, and sexual misconduct policy. We have 5 schools at Pepperdine. All of them have their own policies, but really in this realm, all of their policies are essentially the same thing. There's minor differences on who sits on each school's judicial panels that hear these cases. As well as some of the examples we provide for what sexual harassment and other things are geared specifically for a graduate school to make sense in a graduate school setting. I'm aware that some educational institutions do maintain separate policies. Some really group in sexual harassment and assault in one policy, and then others have more of a domestic violence, dating violence type policy. I would be really interested to hear from anybody on this panel or any other panel how that's worked for them, and the advantages or disadvantages of maintaining a separate policy in that area. Also, too, Pepperdine applies the same judicial procedures that we apply to all of our student code of conduct claims, except with several listed exceptions that are called out in our policies. And those exceptions include that we take students off of our judicial panels in these types of claims. We also try to get a mix of both female and male individuals on our panels. We allow for a separation of the complainant and alleged perpetrator in these hearings. Both sides are allowed to call witnesses and present information. And then both sides have a right to get notification on the outcome of the hearing, as well as both can appeal. And most of those differences come straight out of the Dear Colleague letter. So what happens when these cases do get reported to us? What we do on campus is we convene what we call a student care team. The student care team is actually a team that meets once a week that talks about lots of different issues that affect our student population and our campus, but it gets convened when a sexual misconduct claim is reported to us. And our members on that committee or that team are student affairs personnel. We have our student Title IX coordinator, counseling center, housing and residential life, Office of the General Counsel, and Department of Public Safety sit on that team. And so what happens is that team sits down and goes through what we call a response guide, which is really a checklist to make sure that we're doing everything we need to do. And so the first stage is the policy section, and we make sure that we're applying the applicable policy to the situation. If it's a graduate student, it's going to be the School of Law's policy. If it's an undergrad student, we're going to apply that policy. Also, we're going to look at if it's a student-on-student claim versus a student-faculty member claim, because there's different procedures that will get triggered depending on who's involved. The next stage we get into is the initial interaction stage, and this is where we ask a lot of different questions. Because these claims can be reported to different people on campus. It can be in the middle of the night to public safety. It could be the counseling center a couple weeks after an incident happens. It could be directly to student affairs. So we want to make sure that we've been covering all of our bases on making sure everybody's alerted. So we want to make sure our Title IX coordinators are on notice. Department of Public Safety has been notified, and other key administrators that have a need-to-know basis. Also, we're going to look at whether the complainant's needs have been addressed at this point. Have they been referred to counseling, either on or off-campus resources? Have they been apprised of our internal judicial procedures? Do they know that they can get support from us to help them file a criminal complaint, or the option to get a restraining order? And also there's other civil options that are available. This is also too where we look at interim measures. Do we need to remove the alleged perpetrator from a class or a living situation? And also, does the complainant have friends or family who know about what happened, and do they have support from their friends and family? So we're going to want to ask those types of questions. Also, too, we're going to decide whether or not we need to issue a timely warning for Clery purposes, and we're also going to talk about the alleged perpetrator's needs at this point. Very similar to the complainant's needs. Have they been referred to potentially on-campus or off-campus counseling services? Do they need help notifying professors that they may be absent from some classes? And do they have friends and family that are supportive of them too? Then the next stage we go through is the investigation stage. That's where typically the case is handed off to public safety to do the witness interviews with coordination from the student care team and some direction given from the team. Also, DPS will talk to local law enforcement if necessary. And then at this point, DPS will send their reports back over to Student Affairs to determine what they're going to do with the case. So this is also an area at this point where we have to look at the complainant's wishes. Oftentimes they tell us, hey, we don't want you to pursue any disciplinary action. And this is where we have to make that very, very hard call on whether or not we're going to honor the complainant's wishes not to go through the disciplinary process, or if we have enough evidence and it's egregious enough, or we think there's a risk to other people in our college community, that we're going to go forward anyway and not honor the complainant's wishes not to go through the disciplinary proceedings. And then finally, our last part of the process for the student care team is the institutional response. So typically we'll reconvene once we have a final determination in the case and decide if there's additional actions we need to take. You know, is this an area where we're getting complaints of sexual misconduct pretty frequently? Maybe we need to do some outreach efforts, go train that student group or that particular area on campus. So we'll look at the bigger picture at that point. And then very, very quickly, just wanted to go through our training initiatives on campus. We've, for many years, had a freshman residence hall sexual assault prevention presentation that we give to all of our freshman students, but this year we actually have added in a conversation on domestic violence, dating violence, and stalking. And then this year with our graduate students, we have gotten in front of them briefly to discuss all sexual misconduct and provide them a 2-page handout kind of talking about sexual misconduct and the resources that are available and the policies that are applicable. We started an email campaign this year where we send out information to all of our students that give them resources, remind them of the policies, and provide some web-based training on sexual violence. And we're just continuing to explore at this point what else we can do on our university campus that we haven't thought of yet that might be working for other institutions. And so I'm hoping, even just being here today and this weekend, that I'll get more ideas for our campus on how we can better educate our students on these topics. So that's all I have for my discussion, and I'm going to turn it over to Nancy to discuss Title IX and its applicability to these types of claims and her experiences.
Thanks. Is this on? Yeah, okay. So I am going to do two things. I'm going to try to speak relatively briefly at the theoretical level about Title IX and why Title IX applies to both sexual violence and relationship violence, dating violence, domestic violence, however you want to put it. And then, so at the theoretical level, things are quite similar. And Title IX covers all of this violence. But then at the detail level, there are some specifics in terms of representing victims of relationship violence as opposed to victims of sexual violence, particularly in internal school disciplinary proceedings that I think are really critical to keep in mind. So I'm going to spend hopefully most of my time talking about that. So starting with the 10,000-foot theoretical level, the Title IX Sexual and relationship violence are quite similar in the sense that they are both forms of sex discrimination and therefore are covered by Title IX, because Title IX is this very short statute that simply prohibits schools from discriminating on the basis of sex. So actually, Title IX does not mention either sexual or relationship violence in the text of the statute. All it talks about is sex discrimination. And this is a difference from VAWA, or from the Campus Save, what Nidad referred to as Campus Save, which was a part of the Violence Against Women Act of 2013 and amended the Clery Act. So in the Clery Act, in what is now the Clery Act, under those amendments, dating violence and domestic violence are explicitly mentioned as forms of violence that are covered by the statute. And sexual assault as well, which has always been the case from the beginning with the Clery Act. But none of these forms of violence are actually mentioned in Title IX. Nevertheless, they are covered. And they are covered, the way we've thought about them has really started with sexual violence. And sexual violence is prohibited by Title IX because it's a severe form of sexual harassment, and sexual harassment has been recognized the world over as a form of sex discrimination. So this is sort of where we've been on college campuses and in education. It's been widely recognized for quite a while now that sexual violence is covered as a form of sex discrimination. However, relationship violence is also recognized the world over as a form of sex discrimination, and this is particularly under international law. And the idea is that state governments and nation states can engage in sex discrimination when they tolerate domestic and other forms of intimate partner violence that disparately impact women. So we heard from Jeff earlier about why domestic violence and other forms of intimate partner violence have a disparate impact on women, and that makes them a civil rights or a equal protection violation under international law. In the US, laws prohibiting domestic violence have generally tended to be passed under the criminal law, within the criminal law, or as family law statutes, as opposed to as civil rights statutes. And this makes a difference because at the same time, our Supreme Court has refused to recognize disparate impact discrimination under the Equal Protection Clause of the US Constitution. So what this means is that under US domestic law, it has been less recognized that domestic violence and relationship violence is a form of a civil rights violation and a form of sex discrimination. But under Title IX, it absolutely is. And we can use the international legal precedents to sort of bring that point home. And particularly since Title IX, Title VII, other federal civil rights statutes, they do recognize disparate impact forms of discrimination. So we don't need to be, in the context of the civil rights, the domestic US civil rights statutes, we are not limited in the way that we would be if we were proceeding under US constitutional law. Okay, so I just put up on the slide an article that I wrote that made this point about the similarities between Title IX and international legal precedents related to domestic violence in particular at much greater length, it being a law review article. And it's available on my SSRN site, which will be on my last slide. But I just wanted to, for those of you who are interested, I thought I'd put it up there. Okay, so that's the 10,000 foot level. It all looks very rosy. But when you get down to the details, sexual violence and relationship violence can look very different. And this can be quite damaging when it comes to actually litigating these cases in student disciplinary proceedings, which is how I have mainly dealt with them. Okay, so on this slide is an excerpt from an open letter by a group of attorneys who do a lot of consulting with colleges and universities on Title IX matters. And as you can see, the attorneys present the victim's report of sexual violence as a case of revenge by the victim against a boyfriend who jilted her. They actually refer to her as a woman scorned, right? Because Shakespeare is where we want to get our guidance on how to deal with these issues. So when I saw this account of the case, I thought of something very different, right? It seemed to me that this could be a case of relationship violence that was improperly presented as one of sexual violence. And I say this because I represented a relationship violence victim in an internal disciplinary proceeding that looked very similar to this one. My client was involved in what could be described as an illicit relationship because she was involved with a male classmate who was married to someone else. And he was a friend who then turned into a sexual partner. He was also abusive and extremely manipulative and managed to convince her to engage in this relationship due to his unhappiness in his marriage. But my client felt guilty throughout the relationship about the cheating and tried several times to end the relationship as a result. And every time she did so, he raped her, and she would stay, and she never reported any of that violence. Finally, he broke up with her and then regretted it and tried to get back together. But she was like, I'm done, right? She had been trying to do this on her own for quite a long time, and so she took the opportunity to get out of the relationship. And when she refused, he raped her again. And that was the rape that she reported. And so she got to me because I represented students in these cases. And the first thing I did was I said, relationship violence, you need protection from this guy beyond the boundaries of our campus. The first thing we need to do is get you a CPO at DC Superior Court. So that's what we did. And for those who know DC Superior Court or the DC system, you know that we have a specialized DV court. And she got the CPO very effectively. And the judge, who was an appointee of George Bush Sr., actually took the time to write an opinion on the case and deliver it from the bench, identifying the abuser as having engaged in abusive practices literally on the witness stand in the courtroom. And so the CPO proceeding was quite successful. Then we litigated her disciplinary complaint in front of a non-specialized, non-DV trained hearing panel. And the student disciplinary system on top of that was used a modified prosecutorial model, and I, as victim's counsel, was not the prosecutor of the case. So I've actually written about this as well. I have an article that talks about decriminalizing institutional responses to campus sexual assault that deals with why the prosecutorial model is not good for these cases. But what that meant in the context of this proceeding was that the prosecutor was also untrained in DV. The only person who knew anything about DV was me. And I was not prosecuting the case, and I was not on the hearing panel. Counsel for the abuser used what I sometimes refer to as the slut defense very effectively to defend his client. And so we did not get a good outcome for her in the disciplinary proceeding. And the experience just generally taught me that we need the domestic violence bar to be getting involved in these cases, that we need folks, attorneys and faculty who understand sexual and relationship violence and all forms of gender-based violence as civil and human rights violations, as well as just the dynamics of this kind of violence, so that these cases can be properly litigated, and so that we can get faculty and staff who are trained and understand, so that we can do some of the training that we've done for decades with judges, for instance, that we can start to do those with our internal folks who sit on hearing panels and are involved in actually investigating these cases on college campuses. We need to start to bring what we've learned in the more pure legal context to the administrative processes that we are creating on college campuses and that we are doing on college campuses. And we need folks who understand that on college campuses, Title IX makes this a civil rights issue, makes this a human rights issue, and makes this an issue of sex discrimination, which actually is hugely important because it gives us a lot more legal methods and a lot more administrative methods to deal with sexual and relationship violence as an equality matter as opposed to as a criminal law matter. And believe me, from having done these cases and been what I call the Title IX broken record, when you shift from a criminal model to a Title IX equality model, it changes everything. And it is so much better for the victim in so many ways that I could be here at 5 o'clock and still be listing them. So I end with a call to action for all of you that we've already heard about the different ways that folks are getting involved in this issue on college campuses, particularly the incredible sea change that the incredibly courageous student survivor activists have initiated on college campuses, but even how a donor has gotten involved in spurring change on this issue. So I'm hoping that the faculty and attorneys in this room in particular to please, please, please bring your experience, your expertise in these issues and dealing with this violence in the legal context to what is happening on college campuses. And whether it be your campus or other campuses, please start to really bring everything that you know about these issues in other contexts to bear on what is happening on the campus. The Title IX bar is minuscule right now, and we desperately need more lawyers and more faculty in the movement. So I will end with that, and I believe that Jill is going to tell us a lot more about how you can do that.
Yes, thank you very much, Nancy. It's really inspirational. And I'm going to begin where you left off, I think, with a message from a colleague who some of you may actually know, who is in State College now, where I teach at Penn State, but practiced in Baltimore and DC for many years in doing domestic violence protective orders. Her name is Justine Andronisi, and she also has represented and still does victims in the Jerry Sandusky case, which unfortunately our campus became notorious for. And Justine, when she found out that I was presenting at this event, she said, just make sure that you tell them that we're not doing enough. And she reiterated that several times, and it was remarkable to me because she's someone who's out there in the trenches every day doing so much. But that's really her mantra, and I've worked with Justine for many years now, and done a lot of projects and some presentations with her too. And the last time we presented together, she cautioned against what I think is not a. This happens, I think, not because we mean it to happen or because we are egotistical, but she said, you know, sometimes in this field we fall into the trap of becoming self-congratulatory because we are out there doing such difficult work, and it is so traumatic sometimes, and we have to remind ourselves that we're doing it for a reason and that we really are making some sort of a difference. And that is all to the good, and we need to remember that. And Jeff's talk was so inspirational on that front. It was authentic, and so was the dean's. We are doing important work, but I think Justine's point is well taken as well. That's fine, and we need to pause and acknowledge that what we do and what all of you do, even the students who haven't started the work yet, it's very important, and we're not doing enough. So please continue to join together and to do what you're doing, because a rising tide lifts all boats, hopefully, and we have to keep recruiting people, and we have to keep doing what we're doing. At Penn State, I'm very privileged to run a law school clinic who does do victim advocacy work. We work with victims of domestic violence and sexual assault, as well as other family law clients. But at Penn State, the tragedy of the Sandusky scandal is and always will be with us. It played out in the courthouse that I have pictured on the slide. It's been in our background for 3 years now, and it was an unmitigated tragedy. It also spawned the seeds of hope. Hope for other victims who came forward in record numbers after Sandusky was brought to justice in this courthouse. One of those victims was his own adopted son, Matt, who was represented by my friend Justine, and who came forward during the trial, and has now founded his own foundation called Peaceful Hearts, and is one of those survivor activist, very special individuals. And there's also been hope that I think's been leveraged for campus advocates who have been able to themselves then leverage support from a lot of different sources in our community to do several different things, and I'm going to talk about some of those today. So if you know anything about Penn State, and I know there's at least one person in the room who's a Penn Stater, we're everywhere, right? We're so enormous that it didn't surprise me at all to walk into this room today and teeny tiny, this teeny tiny room on one campus, and there was Shelby, who said, I went to Penn State undergrad. Well, of course, there's a Penn Stater here. So Shelby knows what I mean by we are. And I loved that when the dean gave her talk, one of her most impactful sentences to me, and I was writing it down, began with those same two words. She said, we are about very serious work today, and I'm hoping it ripples across the country. And I personally know that it will, and that it does. At Penn State, we are is a Penn State spirit saying, but here's what we are means, I think, in this context. Some of the efforts of my law students in the family law clinic at Penn State are just one example, but across our Penn State campus, we've seen a number of different campus organizations, including law enforcement, which Nida spoke to, campus victim advocacy groups, the administration, and student groups organically formed to try and support victims, have been, and will continue to join together and partner. And I'll talk a lot today about specific partnerships. So what I think we are doing at Penn State is we are cultivating approaches to address violence and to prevent it. And it starts with what I've addressed on the slide, which is education, changing the cultural conversation about intimate partner violence and about sexual assault. And as has already been discussed today, that false divide between those two things has to be constantly bridged. And I think that's one of the takeaway messages today from our panel. And finally, I think we're improving outcomes. I really do. I'm an optimist like the dean, and I see those silver linings every day, or else I would just stay in bed and be depressed. So I do think we are improving outcomes for not just helping victims, but also for holding perpetrators accountable. And although it is sometimes frustrating, I think that we are raising consciousness, as the dean also said, and we're moving forward in that direction. So what are we doing specifically? I have a couple of things to point out. One is, I think listed at the top of my slide in light blue is a website that we started at. I shouldn't say we because I had nothing to do with it, but because we are Penn State, I guess I can say we. Some of my colleagues, one of whom is one of the lead detectives on the campus police force who specializes in domestic violence cases or dating violence cases, and another who is a long-time 30-year victim advocate who's worked in the community and now works on campus. They were the leaders in developing this website, and if it's not too disruptive, I may get up and actually click on it and try to show you a little bit about it, because I think it bridges that false divide, but in 30 seconds maybe I'll do that. Let me tell you about a couple of other things on the slide. We have on campus, very recently, the president directed that a sexual assault task force be formed, and he appointed certain members of the campus community to that task force. Many of them are campus leaders. We have the director of our Center for Women Students, who is another 40-year victim advocate. And so I've put on the slide some of what I see as the key language in that charge from our new president. And this gentleman, President Barron, became Penn State's president in June, and on July 3rd, he issued this directive. So this was clearly a priority for him to indeed change not just the culture, but to change what we're doing and what we're doing to address it. And then finally, I wanted to talk, and I have a student who's actually going to join us by virtual reality, and we'll talk about some of the work that we do on the, not quite, on what we call the Bystander Intervention Task Force. Jeff, if you wouldn't mind, can you just click on that light blue link for just a second, and I'll show them what the website looks like. If you Google Penn State Share, you kind of get to it. It's so new, it doesn't have enough hits yet to come up on the top of that Google search. But the URL now you can see if you're interested in actually taking a close look at it. I think it's very well done. But just quickly, the thing I wanted to point out today is that right there on the top in that first paragraph, I believe, it discusses sexual assault and dating violence and intimate partner violence together. It's just one way of bridging that false divide, shows victims where the resources are, and I think just starts to sort of change not just the availability of resources, but our reality and what our conversation is. Okay, so we can take that down and go to, the next slide actually shows, yeah, we just gotta get hooked up onto slideshow mode, yep. Yeah, so this is our law school building, and this is where some of our work actually takes place. The courthouse that you saw on the first slide, where Sandusky was brought to justice, is where my law students in my clinic practice. So they're going into that same courthouse and getting rid of that negative energy every day by sometimes gaining protective orders for clients, sometimes working on a divorce for a survivor, and lots of other types of, not lots of, but lots of family law cases of certain types that aren't relevant to today's talk. A fair number of our clients in my law clinic are actually Penn State students. And so and that's new for us. We've just started seeing more students coming through our doors in the last year or so. And I think that's a direct result of Sandusky and the raised consciousness on our campus. And I think we're getting those referrals because the conversation has changed. In fact, I want to take 10 seconds for each and tell you about two recent cases. Last year, we had a law student come to our clinic and disclose her abuse and ask to be represented. And it was a little complicated because she also disclosed that she was hoping to work in the clinic in the future as a student. So we had to think through the complexities of that and the awkwardness and potential confidentiality risks and privacy concerns about her being represented by one of her colleagues in the law school, which she was. And we went forward with that and worked side by side with the campus student conduct office and the other collateral offices in student affairs, which are featured on that website, to assist her through the on-campus proceedings that she was working with them, regarding him and his potential consequences. But we also litigated her protective order case as well. And then recently we had a student-on-student dating violence case where we were able to get a protective order for a student who was in a dating violence situation which included sexual assault. And one of the ways that his abuse manifested was on Twitter. And he tweeted, the day that she filed for her protective order, he tweeted, and I quote, "I hope that bitch keeps getting raped." And we used a printout of that tweet in court, which by the time we got to court he had taken down, but luckily we found it in time. And it was a very poignant moment on the stand when he tried to deny that he meant her by that tweet. And my student cross-examined him by saying, "So your testimony is that it was just some random person that you hopes keep getting raped?" And he said, "I don't know, anybody, not just one person, I guess." And the judge looked at him and said, "So your testimony is that you tweeted that you hope women get raped." So we got that protective order. So he granted the petition. And lastly, before I introduce Courtney, who's pictured on the slide, who is a survivor herself and who has done an amazing amount of work in her young life already, Courtney was one of our students last semester in the clinic, and she has worked on many projects and helped us put together one handout that I have, which is going to be available right outside the room if you'd like to take a look at a copy of it. This is a brochure that we produced in our clinic upon the suggestion of one of our clinic students who said they didn't think that any of their student colleagues understood what getting a protective order was, that it even was a thing, that it was an option. And Courtney will talk more, I think, about that, as well as some of the other work that she's been doing. So, if she's available, I think we'll hear from Courtney for a few minutes. So this is Courtney Keel. She's one of our third-year law students, and she'll be graduating in May.
All right, let me do a test. Courtney, can you hear us?
Yes, I can. I'm afraid that you're going to echo on my computer. Can you hear me?
Yeah, we can hear you well. Thank you.
Okay. So hello, everybody. I can't see the audience, but I can see the panelists. Thank you for doing this. This is wonderful. And thank you, Professor Engel, for having me speak a little bit. So as the slide shows, we've done some different projects in the clinic, and one of them is the PFA. That in California, those are just restraining orders, but in Pennsylvania, it's a protection from abuse order. And the brochure just briefly goes through how to get it, who can request it, what happens next, and gives you some resources. And I'm actually also an intern at our Center County Women's Resource Center, which kind of gives me an interesting connection with everything that's going on in our little community with all of this work, because everyone is doing a lot of things, and as Professor Engel said, and Justine has said, we're still not doing enough. And I think I'll talk a little bit about the different task forces that are going on. So there's a bystander intervention task force, which I'm sitting on, and it's comprised of students, faculty, researchers, counselors, and everybody is working together. It's great because you have so many different perspectives that are all being brought to the table to try and figure out what's going to be best for our campus. And we've broken up into different small working groups, looking at different projects. It's all very interesting, and it's great to meet other people who are involved. And for Jill and I, we're able to bring the lawyer perspective and represent that. So there's that task force. There's also a sexual violence awareness roundtable, because when I first started getting involved with this work at Penn State, I wanted to try and identify all the different student groups that were doing work with these issues. And after everything that happened with Sandusky, there are a lot. There's ones that are focusing on child abuse, there's ones that are focusing on consent, there's the male groups. So there's just so much going on. So the Sexual Violence Awareness Roundtable is great because we bring all those people together to plan our events and to coordinate. I think the coordinated community response is what we really need to deal with these issues. So that's what's happening, and it's great. But like I said, there's that roundtable, there's the intervention task force, and there's also a sexual assault task force. So there's also the complications of coordinating all of these groups in our efforts, but we're working through it, and I think that really good work is being done, and it's exciting. So, I don't know what else you want me to talk
Great.
about
No, thank
now.
you. Right, thank you, Courtney. That's absolutely, and I think we're probably getting short on time anyway, so there's not a whole lot more that I want to add. I think it's just inspirational to see Courtney's energy, and she's also been involved with Know Your Nine, which we're so honored to have Dana Bolger here today to talk about that. I just want to close with a point that Courtney was making, which is that at Penn State, particularly on such a large campus, that's one of 40-some little campuses that we have across the state, having a coordinated response is a really big challenge. And so even just on our campus, where we have 40-some thousand students, we are working very hard to make sure that there's not overlap and that there's not redundancy. And that effort, the effort to coordinate without repeating, is really inspirational. And the groups are finally beginning to work together to make sure that happens, as is the administration. And it's not perfect yet, but it really is the key, and we're finally seeing that happen. And just to close with a point again about Twitter and social media, I don't know if we can do it on the slide, but no, not that one, the one right before it. I just put up a couple of the burgeoning social media tactics that have come about in the last year, really, besides Know Your Nine, which is a little older than that. But just at the bottom, I have the Circle of Six, and actually the other one is so new, I forget what it's called, but
It's on Us.
It's on Us, right? And so everybody's probably familiar with It's on Us because it had a huge public launch from the White House recently.
Because it involves John Hamm.
Right, and because it involves John Hamm, as well as other celebrities. Kerry Washington is pictured on the slide. This is all to the good. And although we have cautionary notes, I'm sure, about each of them and all of them, but when you can hashtag It's on Us and hashtag Circle of Six and hashtag, we know we're now hashtagging, it's such a good one. There's a Penn State one that we're doing. It doesn't matter. You have to figure out what works on your campus. But social media is extremely powerful. And when it's used for raising awareness and changing that conversation to a positive way, we start to drown out those tweets along the lines of the one that the defendant in our case tweeted. So that's all I have. Thanks.
So first I want to just thank the entire panel. I think what we've given you is an overview of kind of what the framework of Title IX looks like and what the real possibilities for change are within that framework. Thinking about expanding the really amazing work that's been going on all over the country, and also what the challenges of that work are, both in terms of expertise and in terms of definitional issues. So there's a lot to talk about. I have questions, but I will not exercise moderator's privilege. I'll open it up to you first, and then if you're shy, I can certainly fill in. So, questions for our panel? Yes?
I can just say quickly, it is in Pennsylvania in our statute. It's former partner is included in the statute, and that's true in some other states as well.
So I served on the negotiated rulemaking committee that negotiated the rules that are coming out sometime by the end. I think November 1st is the deadline that they're shooting for, that the final regulations will come out. And it's complicated because Clery is a consumer law statute, and so a lot of it is just about notification and reporting. And the dating violence definition, dating and domestic violence definitions are about what the school has to report. It's not about necessarily about how you would, say, deal with those cases in a disciplinary proceeding. And there were lots of discussions about, there was this preliminary discussion in the committee about how do you identify whether or not this is even a dating relationship. And I was successful in eventually getting everyone on board with allowing the student who's reporting the violence to define whether or not it's a dating relationship or relationship violence as opposed to something else. So, when you get down to the granular level, it gets so incredibly complicated. And personally, I think that if you can solve those complications by putting the power into the hands of the victim to define what is going on, that's the best approach. But it's very complicated because there are state laws, there are institutional definitions, there are now federal definitions, and you have to kind of work it all out.
To navigate what fits.
I agree with that. On the Clery definitions, it's both current and former spouses, and also with the dating violence definition, it's the same. So that doesn't matter. But what really does complicate it, especially in California, is although we use the Clery definitions right now as how we define for the purposes of our judicial code of conduct, that's what we're using. We're actually obligated to train the community on California's penal code definitions of these things. And unfortunately, they don't completely match up with the, there's a domestic violence, but there isn't necessarily really a dating violence penal code. And then stalking is, so it's really complicated for college and universities, communities right now. And I'm really hoping that we're going to get more, guidance on these issues out of the federal government, because it's super confusing and there's a lot of room to not really address these claims, right, because we don't know what we're supposed to use.
But just from a policy matter, as a policy matter, just keep in mind that institutions, for the most part, institutions have really wide latitude. Yeah. The legal definitions are the floor, okay? You can go above that, and you can create a policy that is very clear about how we as an institution, we are Penn State, right? How we as an institution are defining these forms of violence, and that then gives you a way to address that violence when it happens on your campus.
Deborah.
First of all, thank you. This is so informative and so very helpful. I have a question about mandatory reporting, particularly as
I mean, it's a state by state question, I think. So I could talk about what happened in Pennsylvania, but I don't know if
Are we
either of
talking
you
about
wanna-
minors? Because when I
Right, so
when I
it's-
hear
so
the
that's-
term, this
that's
is two
for the first
different.
one.
So Deborah, just to clarify, are we talking about your reporting requirements as a mandatory reporter under Title IX and under Clery?
Okay.
Yeah. So it's not, I don't think it is state by state. I think we're talking about the federal
I
obligation.
thought you were talking
Right.
about
Yeah, when I
abuse of
hear
kids,
mandated
abuse of minors.
reporter.
Yeah.
Reporting does contract, child abuse and the like,
Right.
but no, I'm asking about
Title IX.
what you're all talking about.
Yeah.
So the place to look is in the new FAQs for Title IX. What we tried to do was set up something that was similar to the military reporting structure, where there are restricted reports and non-restricted reports, and the restricted reports are totally confidential, and the non-restricted reports will get advanced up the chain. And the restricted, that dual reporting structure was created in the military and has been somewhat imitated with certain, it's been more difficult to implement that in the campus context, but the idea is to provide victims with dual reporting options, that one of which they can control pretty absolutely, and another one of which is more in the hands of the institution to decide, for instance, if there's an ongoing danger in terms of someone who looks like a repeat perpetrator, that even if the victim requests confidentiality, the institution decides, no, we have to move on this. So the FAQs define certain roles on campus, but they also put a fair amount of power in the hands of the institution to simply define which reporters or which employees on the campus are confidential and can remain confidential, and which are responsible employees under the Title IX guidance conversation, or the guidance language uses the term responsible employees. And so it's a little bit complicated, and I won't get into all of the details, but there is a significant amount of power given to the institution to simply define who it is that can be in these different categories of employees, and to just make that transparent to students so that they know what is going to happen when they report to this person, this employee, as opposed to this employee. Now, state privilege matters here too, right? Because most attorneys are going to have a confidentiality privilege that comes through their license and through state law. And so privileged employees fit into the confidential employees category under the FAQs, under the Title IX FAQs that were released at the end of April by OCR. So my view is that most barred attorneys are going to be covered by state privilege and therefore be confidential.
So I just want to pull out as the moderator, there's an interesting theme here that echoes a theme that we've seen in domestic violence law and policy for quite some time, which is about the relative allocations of power, right? So in these schemes, who has the power to determine whether a process is going to go forward? Who has the power to determine whether things are going to be confidential? One question that I'm not going to ask right now, but I'll put out there is, how do we want to allocate power here? Nancy talked about a regime in which we allow victims to define dating violence as they would define it, right? Because we want to put as much power into the hands of victims as we can. And Nada talked about how Well, we do that up to a point in terms of reporting, but there's a point at which institutional interests may outweigh the interests of the individual. That is a debate that has been going on in our community forever about things like mandatory reporting and no-drop prosecution and other kinds of domestic violence interventions. So how we think about those things in this context really needs to be informed by all of that conversation that's gone on before. Joanne, did I see your hand up before?
You're so lucky. Everyone's looking at me.
I'm looking at you and Nancy. I mean, I
can't speak to the institutional response. I could only speak to the victim's reality and how we can try and help her manage that. I don't know if any of you want to speak to institutional response.
So I'll try to speak to institutional response. If I was the administrator in this situation, what I would be saying is, first of all, if the abuser is at another institution, I would be on the phone to the appropriate person at that institution to say, how can we work with you to get this student disciplined and deal with this situation at your institution, because you're the ones who have jurisdiction over this student. And this is actually a burgeoning area in this law, because the situation that you're talking about, where the perpetrator and the victim are across the country from each other, is the more common situation is where a group of colleges and universities have a close consortium, and there's a lot of interaction between the student bodies. And there are schools that are saying to victims, oh, I'm sorry, even though that school is a mile down the street, and even though you take classes there and he can take classes here, and we have all of these cooperations, there's nothing we can do. And that is wrong, and I think that's, there's nothing in the law that says you absolutely have to do it this way, but from my perspective, the school, and under the OCR guidance certainly, the school that the victim goes to is responsible for protecting her Title IX rights. And so that school is responsible, even if they don't have jurisdiction over the perpetrator, they're responsible for doing, as much due diligence as they possibly can to address the violation of her rights. And one of the ways in which they can do that is by making a call to the appropriate administrators at the other school. Another way to do it is through a CPO in that jurisdiction, right? To just, I think a lot of this is just about thinking creatively and remembering that you as the institution have the responsibility to protect her rights. And whatever you can do to do that is what you should be doing.
So Nancy, let me ask you a question. It seems to me that it's been, in some ways, we frame ourselves too narrowly when we focus on the disciplinary process for students and not so much on kind of the university's affirmative responsibility to keep its students safe. So would we do ourselves as advocates, and do the university a problem, but really as advocates do ourselves a favor in terms of talking about what is a university's affirmative responsibility to keep its students safe, regardless of whether that perpetrator is another member of a university community or not?
Yeah, no, and I think, you know, for me, the focus on Title IX is not just about keeping our students safe, but about enabling them to continue with and succeed in their education as close to the level of success as they would have had if they had not been a victim of this violence. So it means not only keeping them safe, and if what you have to do, you know, if you've got an active stalker, for instance, safety is going to be a huge thing that you need to deal with, right? But you also, you can't stop there, right? You can't stop with the disciplinary proceeding or the investigation. You also have to be thinking about what does this student need in terms of accommodations to continue with her coursework. She may have active PTSD. What kind of mental health support does she need? What kinds of triggers are happening for her on the campus that you might be able to help her deal with by switching her to another dorm or helping her with her classes? You know, a lot of victims, particularly in the immediate aftermath, have a really hard time completing their classes, right? So is there a way for you to get them out of those classes and not have an incomplete appear on their transcript and not have them, you know, have to pay tuition for that class, which they were unable to complete? And, you know, all of those things which are fairly typically done in the case of disabilities should be done in the case of victims of violence as well, but oftentimes we stop at the disciplinary proceeding and don't get further.
Nada?
So I wanted to weigh in on this. Oftentimes when we see the cases where we don't have jurisdiction over the alleged perpetrator, oftentimes we don't get a lot of information about who this alleged perpetrator is, because at this point, student goes to the counseling center and talks about what happened to them. They were sexually assaulted off campus. No, it wasn't another student, but they're not willing to give us any more information. So oftentimes I think it's going to be a very rare situation where you're going to know, oh, this is a student at a different college, and we might have the opportunity to call over to that other university and say, hey, by the way, your student was involved in this situation, you should handle it. I haven't seen that. I think that's really the rare circumstance, at least for us on this campus where we're located. But what we would do is we would do exactly what Nancy was talking about. We'd give the victim support. We spend a lot of our time in our process when these get reported, as I went through in my presentation. Do we need to get them into on-campus counseling? Is there an off-campus resource that would be better for them? We'll provide them free escort. We want to make sure that they're getting all the emotional support they need, even though they may not tell us who this other person is that was involved, or we know it's not a student. We're going to provide resources, but it's not necessarily going to be a legal question at that point, or that there's really an institutional legal response that we're going to take. It's just making sure that they get the support and interim measures and academic support that they need at that point.
I thought I saw a hand. Oh, okay. Yeah.
I was wondering if you could speak a little bit about the response you're getting at the state legislature level in order to enforce these at the local level. I mean, I know the Title IX rights, and very briefly, a little bit of discussion of, you know, what legally is required at the federal level, because that's sort of all that we have for the city's board. But states really are the ones that define dating violence and protective orders. I don't know if you can speak a little bit about what you're finding your state legislatures are doing, or if there are trends that are moving in a particular direction.
Well, in California, a lot of it, as I believe Nancy and other panelists said, we have obviously our penal code, which is really addressing a lot of domestic violence and these types of issues. But in California, we just had the yes means yes law get enacted, and there is some discussion in that law about how we have to handle domestic violence, dating violence, and stalking type cases. So the states are starting to get involved. It pretty much mirrors what's going on in the federal legislation from what I can tell. And if there was any conflict, obviously we would go with the federal law trumps state. But so far, at least in California, it's pretty similar.
It definitely depends on where you are. I mean, in Maryland, we had a big fight last year about the definition of dating violence, and we're unable to convince our legislature that dating violence should be defined as any violence, any abuse that's consistent with our current civil protection order statute that occurs between people having some kind of dating or romantic relationship. They were absolutely unwilling to open the law up in that way. So in a progressive state, right, because I'll welcome you to come sit through our legislature anytime. But in a progressive state like ours, we have a lot of trouble in opening up those definitions, which then makes it difficult to do some of this enforcement kind of work because what they're doing is not a problem under state law. Mm-hmm. Margaret.
Going back on the question, there is a lot that the campus police can do because when I was at Cincinnati, we had a police officer who was particularly knowledgeable on stalking. And with an off-campus, someone outside of the law school community, that officer would alert everyone on campus, provide a photograph of the stalker. If the school, for whatever reason, was unable to issue an order barring this person from campus, they would work closely with the local police to make sure they were alerted to the problem. So there is quite a bit that a school can do beyond the disciplinary process. And it was effective. And they, of course, would notify the person being targeted if there was any sighting of the stalker.
And one of the things that Jill mentioned was a sort of coordinated community response. Mm-hmm. This is a very key best practice in this field. The task forces, I think that, task forces are generally time limited. I think what most campuses should have is a non-time limited working group or sexual violence response team or coordinated community response team. They're referred to in different ways, but the idea is an ongoing group that pulls in campus police, local rape crisis center folks, anyone on campus, including faculty with expertise in these issues, into a committee that meets regularly and that continues to meet regularly and that can act as a task force in terms of handling specific issues, specific tasks that need to be handled, but can also be a sort of general oversight and just like touch base kind of thing on an ongoing basis to make sure that as things come up, there are people who are skilled and who understand the system and are part of the system who can respond appropriately.
Yes.
So I'm Craig, I'm one of the faculty members here at the law school. I have to make a confession here. So this is not related to my area of research, except for tangentially because I teach criminal law and I do a little bit of technology of the law. The Twitter social media aspects of this are interesting to me. And so I didn't know what to expect when I showed up, but I'll tell you this is the first, this is maybe a critique, but not of anybody in the room. It's a critique of people not here. This is the first conference I've ever been to, legal conference or otherwise, where there are 10 men and 60 women in the room. And I don't know what the reason behind that is, because this isn't my area. So maybe this is what you see all the time. So I have a question, and then I have a comment.
Yes, this is what we see all of the time, except for Jeff. Jeff is our token male.
So Jeff's the token.
Jeff is our token guy, so you can join him now.
So, I law school, I was a residence life advisor in Greek life. And what always struck me as odd about violent sexual crimes or sexual violence, however we're defining it, is that when a student was alleged to have beaten up someone, physically assaulted them, they got drunk and they assaulted someone, but in a non-sexual way, they didn't get an appointment that was scheduled on campus with the dean of students in the same way that you would schedule a dental appointment. They instead got picked up by the campus police or campus security, and they were treated as a violent offender. And when I, as a Greek life advisor, received allegations of a student involved in sexual violence, the addition of the sexual modification to the violence somehow allowed them to have the allegation treated in a way where they went to the dean of students' office and they had a conversation, like on their own recognizance. And I remember in one of our meetings, I said, listen, if nothing else, this person should know that sexual violence is a crime of violence, just like an ordinary assault simpliciter is a crime of violence. And if nothing else, campus security should pick them up and drive them to the student affairs and sit there in uniform with the radio and just that little signal that this is a crime, not this is your fratmosphere bro thing that you do. And so I told myself that if I was ever the president of a university or someone who had authority on this, my little executive order would be all crimes of violence will have students escorted by campus security to the places that they go. They'll be treated as alleged violent offenders. Right? We'll still call them alleged, but if I had an alleged knife-wielding maniac on campus, even until such time as it was adjudicated, we would probably have campus security wondering where they go. And I just don't understand why. And maybe that's changed since I was doing this in 03. Maybe this is what we're doing all the time. But I think that the message that the sexual modification to crimes of violence somehow makes it not a crime or a lesser crime. I think that that labeling is having an impact on men. And men see this as a different, lesser crime. It's a questionable crime.
I'm going to cut you off, as the moderator, I'm going to cut you off now. Only because we have about 3 minutes and I want the panel to be able to respond.
Yes, okay, I'll shut up.
Can I just want to, like, very micro level, just respond to what you said about Greek life and men, because there was a point that I didn't have time to mention in my presentation, and it's exactly to yours. One of the things I've been heartened by recently is that as part of our campus sexual violence awareness roundtable, right? And this is one of those ongoing bodies that has very little power on the administrative side, so it doesn't quite address, what Nancy was talking about and what you talked about, with sort of the care team. But this is a student group, and it formed organically from students, and it's been going on for about 3 years. And faculty like myself also sit on this roundtable, and they meet every week, all year, to plan what they'll do in April, which is Sexual Assault Awareness Month. And so at last week's meeting, I saw the chair of the group convince the student who's the chair of the Interfraternity Council, I guess, IFC, Interfraternity Council, so a man. She convinced him to make the event that we're planning for April the accreditation event for all the fraternities on campus for that season, whatever their accreditation requirements are for that season. And it's a talk by Jackson Katz, who some of you may be familiar with, he's the guy, I'm the feminist, it's okay to be a guy and a feminist, and he talks a lot about gender-based violence and why it matters for men too. So
Jill, I'm going to cut you off. I'm going to give Nancy a quick second to talk about this idea that all crimes should be treated the same.
Right. So, the overlay to the why is sexual violence treated differently issue is that the criminal system has dealt with sexual violence so unbelievably poorly. It has been a centuries-long abject failure. There's a great article that sort of puts into this wonderful inverted pyramid what happens to reports of sexual violence, you know, the ones that happen, of 100 rapes that happen, how many are actually reported, how many result in arrests, how many result in incarceration, and the figure is something like less than 3% will result in any incarceration whatsoever. And so, and in addition, from what I said before about Title IX taking an equality approach, and what I mentioned earlier about accommodations, and what the equality approach does for you, what the civil rights approach does for you, is it allows you to handle all kinds of things that the criminal system will never deal with, right? And so on the one hand, you have this problem with the criminal system having this really bad reputation for dealing with these cases. And on the other hand, you have a civil rights approach that is actually, even if the criminal system were working perfectly, the civil rights system would be better for the victims in terms of getting them many more rights and many more of their needs met. Now, the criminal system, of course, has potentially much more powerful message to send to perpetrators and would-be perpetrators, and I think that's what your comments are getting at. But the problem is that you've got this whole overlay about how victims are treated by the system. And, you know, certainly as a part of, I think, the victims' rights movement, I have very much been in the camp of we need to help and protect the victims first and worry about what kinds of messages we're sending to the perpetrators later, and figure out how we're going to improve the messages that come through the criminal justice system. That's, you know, second on my tag list after I've helped victims get out of these situations and succeeded in their educations.
And to that end, I think one of the questions you have to ask is, what happens to her when he gets put in that car? What are the ramifications of that decision? And that's why some of us have argued that actually, although we've, 40 years of domestic violence is just like any other crime, actually it's not. It's very different because of the relationship between the perpetrator and the person who's been abused. And so while it's great to say we should treat this the same because it's equally as serious and we're sending the wrong message, there's a real person at the end of that whose life is profoundly implicated by those choices that we make. And so we have to be really thoughtful. And on that note, I want to thank our panel again for a really wonderful talk.